Hello and welcome. We're going to be talking tonight about a big topic, a legal topic, a fascinating one, about judges as gatekeepers in our judicial system. With me is the perfect man to do this. Mike Ciresi is my guest. Many of you know of Mike. He is one of the most influential, most respected, most honored trial lawyers in our country, recognized internationally for his work. Probably the case that we think of you the most with is the tobacco litigation case, Philip Morris. And what year was that, Mike, back?
Well, it went from 94 to 98, Mary, and the trial was in 1998.
98, okay. Well, speaking of going back a ways, I found an old cover of a magazine, Minnesota Law and Politics, and I wanted to just put the cover up because the subtitle says, "Where there's smoke, there's Ciresi." And see if there we go. And I thought, that is still true. And now you're with Ciresi Conlin.
Correct.
Get the order right here. Mike, of course, before was with RKMC. So this is a big topic for me. I want to really pick your brain and learn, and I think you'll learn with us, or with me.
I actually had hair there, Mary.
You had hair, but you look great now, too. This was back in 1997, wasn't it? Yeah. Well, thinking of judges and how they get to be judges, two ways, right? Elections and appointments.
Right.
Right?
And it depends whether you're talking about state courts or federal courts. Federal courts, they're appointed.
They're always appointed.
Correct.
Federal. Okay, that I wasn't sure about. Do you think that, and this is kind of a loaded question, but do you think that when a judge is appointed, there is somewhat of a tug, a loyalty to adhere to the appointer's philosophy? Are we dealing with that in conscious or unconscious ways in our judicial system?
Well, I suppose there's always the potential for an unconscious attachment to the appointer's philosophy, but that only would be because, generally speaking, at the federal level, the president will attempt to find people, either he or she, that they think is in line with their philosophy. But I don't think that judges as a whole, and I've never been in front of a judge who I felt adopted the philosophy of the person who appointed he or she. Mm-hmm. So I think
that's good to hear.
Yeah, the one thing I think we have to remember is that it's such a responsibility once you're appointed to the federal bench that I really believe that most people, to the degree they can, and we're all human beings, put aside their biases and prejudices, and we all have them, Mary. We're a product of how we're brought up and where we were and what our experiences were. But I believe that most judges, not all, but the overwhelming number, do put aside those personal philosophies. But when they don't, they can do great damage.
Right. I mean, they've got a lot of power, don't they?
They do indeed.
A lot of power. This is a naive question, perhaps, but do you think that a large number of attorneys would love to be a judge, or is that something that is a small group that aim for that kind of position?
I think some people aim for it right out of law school. Mm-hmm. I think the overwhelming majority of lawyers do not want to be a judge, but a lot of them do. It's a pathway that some set out on, particularly at the federal level. And at the state level, a lot of people just want to serve. They want to serve the community after they've been in the practice for a long period of time. They want to give back. So I think there's a certain percentage of lawyers that want to be judges, but most of the ones I know don't want to be because they feel that they probably couldn't leave behind their advocacy.
Well,
and I think that I can say that for myself. It'd be very difficult for me to sit on a bench and not become an advocate. If I saw one lawyer was a lot better than the other lawyer, I might want to even the playing field. And you can't do that. I think that by and large, most lawyers do not want to be judges.
You're too action-oriented in a sense.
Well, in a way, but I just think most lawyers love practice of law, and they don't necessarily want to be judges.
Do lawyers judge shop at all when they're having that option?
You really can't anymore. You can in some respects. So you deselect. You try to stay away from the judges that you just don't want to be in front of. And in state court, for example, you can file an affidavit on a judge once. So if you get assigned a judge that you don't like, you can file on that judge, and she or he has to automatically disqualify themselves. Then you get the next judge. But you don't know who you're going to get. So sometimes
it's kind of
you're
the
better.
luck of the draw.
Yeah. So sometimes you're better off with the devil that you know, rather than the devil that you don't. So at the federal level, it's very hard to get a judge to recuse herself or himself. It's just very, very difficult.
That's all very interesting. Can we talk just a tiny bit about history? Because as I've been reading, we've gone from jury as main deciders to judges, and back and forth kind of through our history. What's your simple way of explaining the ups and downs of that?
Well, let's step back for a minute. I think that there's two great pillars in our democracy, the ballot box and the jury box. And in both instances, the citizen is the primary actor. So I really favor the jury box. In the sense of our judicial system, as opposed to judges making decisions, because you get a collective judgment, and you get 6, 8, 12 of your fellow citizens who bring all of their experiences, all of their biases, their prejudices, and they mix together, and you come out with what we call justice. An individual doesn't argue that well with himself or herself, and so that's why I prefer a jury to a judge trial. And by the way, most really great judges will tell you the same thing.
Oh, interesting.
So our system is grounded on it. I mean, we wouldn't have had our Constitution without the Seventh Amendment. It was held up because the Seventh Amendment was not in it, the right to jury trial. So it's a very bedrock of our democracy. What's happened since 1993, which is after the Daubert decision, it was a case against Merrill Dow Drug Company, and the United States Supreme Court articulated some factors that should be considered before scientific evidence is allowed to be admitted into evidence. And so it was a question, and it's always been a question, the judge decides admissibility of evidence. It has to be relevant to the issues that are at hand. And for scientific testimony, it has to be based on reliable scientific methodology.
And that's got to have gotten more complex in terms of our history.
It has, but some basic principles remain true, and they're immutable. I mean, if we go back and we look at epidemiology, for example, and this is where it's happened. After the Daubert decision, some federal judges have taken the position that unless you have an epidemiological study that's been conducted by scientists over a period of time that shows causation, that you cannot get to a jury. And that's not what Daubert meant, and that's not what the rule of evidence provides.
Yikes.
But that's what they've done. And the rule of law to prevail is that you have to show it's more likely true than not. If you have causation in epidemiology, it's what's called statistical significance, which means you're 95% certain one event happened because of another.
So the 5%.
So it's 5% it could happen by chance. That's not the rule and the burden that you have in a court of law. It's more likely true than not. So after Daubert, this gatekeeper mythology started, and judges now are excluding evidence because they don't like what the result of that evidence is. And it's not what Daubert was intended for, if you read the case very carefully, and it's certainly not what the Federal Rule of Evidence 702, which relates to experts, provides for. So there's a big controversy in the law right now, in legal circles, about what should be allowed in and what shouldn't.
Is there any recourse case being worked on right now to counter this?
There's no. The law develops, and here's what happens at the federal level. You've got all these jurisdictions around each state, all right? And then there's circuit courts of appeal, and the states are divided up into certain circuits. We're in the 8th Circuit Court of Appeals. So decisions are made at the district court level. They bubble up to the Court of Appeals, and they make decisions. And then when you get inconsistent rulings between courts of appeal, those are cases that the Supreme Court of the United States may take. They don't necessarily take, they may take. So it takes a long time to get a ruling that goes against a previous ruling or upholds that previous ruling. So in the Daubert and the expert testimony situation, we've had a lot of courts around the country that have looked at that case and interpreted it in different ways. So that's what happens.
At the appellate level?
Right. Well, at the district, no, at the trial court level.
Oh, okay.
So you have judges who, they feel that they may not like a case very well, so they exclude the testimony. And that's not what, in my judgment, this is just one lawyer talking, that's not what the judge ought to be doing. What she ought to be doing, or he ought to be doing, is determining whether it's admissible. The jury is to resolve the conflict between competing expert testimony. And so if you, and let me give you an example. Secondhand smoking. Secondhand smoking is known to cause lung cancer. Right. There's no epidemiological study around that says it causes lung cancer. It's impossible. You couldn't have a study large enough.
Variables.
That's right, confounding variables. You need to power the study correctly, which means you'd have to have hundreds of thousands of people in one study, which cannot be done.
Right.
So what you get, and it goes all the way back to what are called the Bradford Hill factors. And I know this gets a little technical, but Bradford Hill was a British epidemiologist who first linked smoking to lung cancer. And what he said is you look at...
Back in how long ago,
Oh,
Mike?
boy, this was back in the early 50s.
Oh, okay, way back.
40s, yeah. And what he said is you look at certain factors, and they became known as the Bradford Hill factors. Is there temporality? In other words, you smoke first, and then you get the cancer after. So that's a temporal relationship.
Cause and effect.
That doesn't necessarily mean cause and effect. It means that there's a temporal relationship to it. Without the temporal relationship, you could never have cause and effect. And that's the only one that is absolute like that. But there's others, the power of it, the gradiency of it. I mean, there's all kinds of Bradford Hill factors that you can look at to make a decision whether or not this object caused this result, right? And that's what epidemiology is. And so what you get is you get a lot of studies out there, and they may go different ways. They have confounding variables. They're conducted by different investigators all around the country. They have different people. And then you start looking at all these studies, and you may put together a picture of causation. So where the battle's being fought here today is on these scientific issues of epidemiology, and some judges say you have to have a epidemiological study that says there's causation. I say those judges don't know what they're talking about because there is no study. You can't do it. There is no study,
right?
Yeah.
And we're talking really just about expert kind of evidence here.
In this area, yes, but the judge is really, if you want to think of the term gatekeeper, the judge is always the gatekeeper of what evidence comes in. She has to determine, or he has to determine, whether it's relevant, and then has to weigh that relevancy against whether it's highly prejudicial. So in other words, its prejudicial effect may outweigh its relevancy or probative value. So the judge is always making those decisions during the course of a trial. Where the gatekeeper terminology came in is this is before the trial ever starts. There are what's called Daubert hearings, where the testimony that's going to be proffered by an expert is presented to the judge before the trial starts.
That's a very interesting thing for we lay people to learn.
Right, and the defense comes up and they say, that in these cases, and that's their right, they have a right to do that under Daubert, no, Mary can't testify because she didn't use the right scientific procedures. There's no statistical significance to her study. There's no other study that shows that what she's trying to show, et cetera, et cetera. And then the judge has to determine whether or not Mary's going to be allowed to testify at the trial.
And
so those who have a very conservative bent will say, we don't like this because, and they'll call it maybe,
throw it out.
It is evidence that, and I don't want to use the term, but I will, they call it junk science. It's sort of junk science, they'll say, so we're not going to allow that in. And so they denigrate it by using that term. The fact is, scientists can disagree. For a long time, people didn't believe that cigarette smoking caused cancer.
Right.
Even though there was biological plausibility to it, there was a temporal relationship to it. You saw that this happened time after time after time. There were individual studies that showed it, that people that smoked had cancer. And what they do is they compare what they call people who are in the case, the people who actually have the disease, and people that don't have the disease. Did they smoke or did they not smoke? But then there's all kinds of variables. There can be, well, all right, were they exposed to asbestos? Were they close to a plant that spewed other types of pollutants? Did they eat this or did they eat that? So all these factors come in, and then scientists make a judgment, a professional judgment, whether they believe there's an association between the event or the catalyst, which would be smoking in this case, or maybe it's a drug, some other nature, and this illness or this disease. And they make a scientific judgment of that. That doesn't mean it's causation, it means there's an association. So you look at that and then you look at all the other factors. We have judges today who don't even allow you to put into evidence what the company knows about its product. Even though they know that it may have this effect or that effect, they don't even let that in.
So are judges getting, in your opinion, much more tight with their rulings of what to admit?
Some judges do, some judges don't. Now, you asked before, do you shop for judges? If you are in a district where you know that these judges are very, very restrictive in what the evidence they're going to allow in, you're not going to file your lawsuits there. You're going to go to Iowa or Nebraska or Illinois or California.
And you can do that without any kind of bias attack on your...
In some cases, you can file in a number of places. In other cases, you can't, because there are certain jurisdictional requirements as to where you can file your case.
So
but if you have an option...
complicated, doesn't it?
It does. But if you have an option to go to a place where you know a judge's not going to give you a chance, as opposed to going to a place where a judge is going to say, all right, I may not agree with this result, but it's scientific. This expert is going to testify to that. The defense will bring in their experts and they'll testify contra. The jury will make the decision. That's where you want to go.
You're up against this as a trial lawyer a lot. How about going up into the Supreme Court? Are they having that same kind of issue going on?
Well, the Supreme Court's not going to take those types of issues very often. They take different issues. That's the Supreme Court of the United States.
Right.
It's rare that you're going to get those types of cases up there. I mean, there's thousands of cases that attempt to get in front of the Supreme Court for discretionary review on an annual basis,
and
they take very few. They take very few.
About how many do they take a year?
I don't know. You'd have to ask
20
somebody.
Maybe.
No, it's more than that.
What is it?
Yeah, but it's not many more. It's maybe they decide maybe 40 cases a year, 35 cases, something in that range.
I should mention to you, the viewer, we're taping in October on the 21st in 2019. There are going to be some big cases coming up this year with the Supreme Court, aren't there?
There always are.
Always are, but some kind of hot button issues coming up this year.
There'll probably be some coming up in politics too.
Could be, could be. In terms of judges and the need in our state, I know our Supreme Court Justice, Lori Gildea, was really pushing for more money to get more judges, to pay them a bit better, to pay the other 2,700 I read employees better. What happened with that? That was back
Well,
in May.
you're right. The the judicial branch of government is obviously dependent upon the legislative and executive branch to fund it properly. And
Right.
there's,
That's kind
if
of
it's
a,
not funded, well,
that's kind of a
that's the way it is.
dangerous
That's the way our Constitution,
situation.
yeah, but that's the way our Constitution is set up. And, people might argue about what judges do or what they don't do. Fact is, without the judicial system, we wouldn't be the country we are.
Well,
and it's
absolutely.
very, and this is just my opinion, people say, well, he says that because he's a lawyer. But I think it's very short-sighted to shortchange the courts, because once you do it and you start doing that, you don't understand how that affects your rights, that they don't have the resources that they need to address all the issues coming before them. And then all of a sudden people come and they say, Mike, how come I can't do this in court? I couldn't go to this court or that court. All of a sudden they find that their rights are being affected, but they don't understand that when you just have this abstract statement saying we need more money for the courts. I think that most of our Chief Justices here in Minnesota, and we have a very good history in this state, but most of our Chief Justices have always been very, if anything, frugal about how they approach the need for resources. I'm not saying they're too frugal, but what I'm saying is that they haven't gone overboard to say that we need money for things that they don't need it for.
Well, it's a small percentage of our state budget in terms of the judicial.
Very small. When
1 or 2%, right?
When our Supreme Court justice and when our court system asks for resources, they're needed.
I believe
It's one of the few times in government that I think I can say that without any hesitation.
Oh, that's interesting. Back to the gatekeeper thing. We've got 5 minutes left only, Mike. What do we need to do? What can be done to improve on this situation that sounds like it's kind of a slippery
Well,
slope?
I think that, if you get a real conservative person on here, they'll tell you the opposite. They'll say that's what they should do, stuff into evidence and blah, blah, blah. But then, all of a sudden people do not have an ability to petition their courts for redress. And we haven't had a runaway court system here. This court system has been the best in the world. Injured people in other countries come to this country for redress. Our product liability laws have set the standard for the world. You wouldn't have seatbelts if it wasn't for the judicial system. And I can go on and on and on and on. So, what can we do? We can appoint judges who are more enlightened than some of the ones that have been appointed. But I'm sure there were lawyers 70 years ago saying the same thing, and there will be lawyers 70 years from now saying the same thing. We live in a democracy. We have the whole range of political philosophies, and it ebbs and flows, and it goes back and forth. Mary, it's like saying today that everybody looks at what's going on politically at the national level and everything else. How can we be in this position? I say, you should have lived in the 60s.
Yeah, things were chaotic then, weren't they?
3 major assassinations: Martin Luther King, the Kennedys.
Right.
We had National Guard killing college students on the Kent State campus.
Right.
We had the Vietnam War.
It's good to be reminded of this.
I mean, we were living in a unbelievably tumultuous time, and America got through it. Okay, and we make errors, we ebb and flow, and we're doing the same thing today. We'll get through this one.
But that is good to hear, because I think there's kind of a weariness and a kind of a low-level anxiety. I think across the board, everyone's.
There is. What's different today is that we have a tribalism that we didn't have in the past, and I think a lot of that arises out of the fact that the proliferation of television statements, media outlets, the internet, which is a major thing, 24-hour coverage, and people today are they go to those media outlets that sound like them and say what they want to hear.
Right.
And I think in the past we were more forced to listen to the other side. And the fact remains that if you take the American population as a whole and put the extremes aside for a minute, those on the far left, those on the far right. 75%, 65% of the people are a little left of center to a little right of center, and they can agree on 80% of the things. Now, that doesn't mean that we don't need the far left and the far right, because they raise up issues that the rest of us who have a little bit more common sense, come to a conclusion on, and we advance the ball.
This is all, it's coming at a good time, I think, for people to hear your wise thoughts on this, because as a lawyer, you're in the thick of things in a way that most of us aren't, and yet for you to have such a hopeful point of view is really, really neat to hear.
Yeah, I mean, if we look at, you remember what you and I can remember this, Mary. Well, you're a little bit younger than I am.
No, I'm not.
But, in the 60s, remember what the parents were saying about us at that point? I mean, this is repeats generation after generation. If you talk to a lot of the young people today, the millennials, as they call them, I mean, I just had a couple in my office this week, just came in they're planning what their career might be in that, and I spent an hour and a half with two of them, and an hour and a half with each one. And I was just enthralled with, the breadth of knowledge that they have, their enthusiasm, and what these kids are going to do when they grow up. So, we're going to be fine.
Well, on that great note, I want to thank you so much for coming down and,
thank you.
And
Thanks,
giving us some of the real insights.
Yeah,
great to see you again, work with you. Well, I've been talking, if you tuned in late, to Mike Ciresi, our wonderful resource here in Minnesota, as one of the top trial lawyers and litigation lawyers in the world. So I hope you were able to join us. If not, we'll replay the interview several times. You can find it on YouTube. Thank you for being with us. See you next week.